For this session, we will talk about your tax remedies. So, you all know that in filing your tax returns, it is through your self-assessment. So, what happens is the taxpayer will file the return and will pay the return without BAR checking if ever that is correctly filed and the amounts presented there are correct. Therefore, what happens if in case the BAR finds out and determined that there are irregularities as to that particular tax return filed, or there is fraud or falsity on that particular return. So what will the BIR do? And in case that the BIR will do such thing, what are the remedies on the part of the taxpayer? So for this session, we will talk about your tax remedies not only as a remedy made by the government, but what are also the remedies of the taxpayer in case there is an action made by the government. So here on your tax remedies, we will dwell on two main remedies. Remedies of the government as to the collection of the false or fraudulent, irregular type of tax return, and as to the taxpayer, whether they could also cancel out that particular remedy of the government. So, what are the remedies of the government and what are the remedies of the taxpayer? So let's start. So as we said, your tax remedies is composed of the remedies of the government and the remedies of your taxpayer. So the remedies of your government can be classified as either administrative remedies and judicial remedies. The same is true with your taxpayer. We have administrative and judicial remedies. So before we finally look into those administrative remedies, let's try to differentiate what is administrative remedy and what is a judicial remedy. So when we say administrative remedies, these are remedies made at the administrative agency level, particularly in the BIR. So these are remedies launched or lodged in your BIR per se. But if that is a judicial remedy, that is a remedy that is lodged to your regular courts. So take note, administrative remedies, this is done through the BIR, judicial remedies done through the courts. Now, one important thing that I want to emphasize with you before we discuss all these remedies is that we have this principle of exhaustion of administrative remedies. Exhaustion of administrative remedies. So, what is this principle of exhaustion of administrative remedies? It tells you that you must first exhaust all available administrative remedies before resorting to court action. Okay? Therefore, before the government could resort to a court action on a judicial remedy, they must first exhaust the remedies provided by the BIR. And what are the provided remedies under your administrative level or under the administrative agency BIR? So here are the different remedies. So first, we have your assessment. So under your assessment, you have learned this already with our previous topics. When we talk about assessment, this is in case the BIR now will look or audit the particular taxpayer to determine if ever there is falsity or there is irregularity or there is a fraudulent return filed by the taxpayer. So the BIR will try to audit. So generally, we use assessment the same with the term audit. Next, you have your collection. Now, in your collection, we try now to enforce payment. We try now to enforce payment because generally, first we try to audit or we try to assess. And of course, what comes after assessment is to collect whatever is assessed. Okay? So, first you assess and then you collect whatever is assessed. The question now is, what if you cannot really collect? Because when we say collect, you must be paid by money or cash. But what if you are not paid with cash or there is no cash available to the taxpayer? So aside from actual collection or to enforce the payment on actual collection, under your collection, your government has different summary proceedings or summary remedies. Summary proceedings or summary remedies. So, what are these summary proceedings or summary remedies? So, in lieu of collection or in lieu of enforcing payment through your taxpayer, you could make summary proceedings or summary remedies such as your restraint, levy, tax lien, and forfeiture. Later, we will discuss what are these different remedies and what are the differences of these different summary proceedings or summary remedies. Now, after discussing soon your different tax remedies under the government, we talk also on your tax remedies of the taxpayer. So what are the tax remedies of your taxpayer? So first, you have your administrative remedies. So again, these are remedies done under the BIR. So generally, we have two administrative remedies. So the first one is to protest, and the second one is to reply. So later we will also talk when do we protest and when do we reply. So when do we use the term protest and when do we use the term reply? And what are the grounds for a protest and what are the grounds for a reply? Also, if all of the administrative remedies had been exhausted, we can have judicial remedies. So when we talk about judicial remedies, again, we talk about your court actions. And when we say court actions, this can either be a civil action or a criminal action. So both taxpayer and the government can have judicial remedies, either a civil case or a criminal case. So what is the difference on a civil case and a criminal case? Generally, criminal case has penalties. So they are penal in nature. So when we say they are penal in nature, you can be penalized either by a fine or imprisonment. So those can be your penalties. While for civil action, you are trying to enforce a civil rights. So what are your civil rights, by the way? So for example, for government, their civil rights is, of course, to collect whatever is the unpaid or incorrectly paid tax. While for the taxpayer, their civil action can either be to deny the right of the government to collect from them. So they could file an injunction, etc. But later we will learn when will the taxpayer can file injunction. So when can the taxpayer stop the government to collect from them or to enforce whatever is distrained, levied, or forfeited property, or what are the different steps in case the government now is to sell your property. So those are what we will talk about with your taxpayer and the government. And aside from that, if you have remembered during our discussion before in midterms, we have a remedy which is available to both the government and the taxpayer. So what is that remedy that is available to both? First, we have your compromise. Okay? First, we have your compromise. So when we talk about your compromise, take note this is different from your compromise penalty. Because again, when we talk about assessment, you are talking about the total tax liability that should be collected from a particular taxpayer. And when we talk about total tax liability, what are the components of this already? We have four items, right? So first, we have your basic tax, if you still remember. And then we have your interest, we have your surcharge, and we have your compromise penalty. Now, what is the difference between a compromise and a compromise penalty? A compromise penalty, as we have discussed before, is a type of penalty, meaning it is an added burden on a particular taxpayer. So this is more of a burden. While a compromise per se, we mean that we try to negotiate the amount of our total tax due and we try to lower them. So when we say compromise as a remedy, it means to decrease the total tax liability. Okay, so that can be a remedy to both the government and the taxpayer. Sir, why can we say that compromise is considered a remedy to both your government and the taxpayer? It is considered as a remedy to both the government and the taxpayer because first, for the government, they can collect whatever they can out of the taxpayer, whether it is a reduced amount, so long as they can collect. For the taxpayer, it is beneficial because they will pay lesser. Again, the government is more focused on the collection of taxes. So whatever the taxpayer can give or can pay, that's okay with the government. But remember the rules on your compromise before we can compromise a tax liability. Next remedy to both your government and taxpayer is your abatement. So what is an abatement again? If your compromise reduces your total tax liability, your abatement erases your total tax liability. Therefore, you have zero tax liability in case your tax is abated. So remember, we have this remedies to both compromise and abatement. We will not discuss these two already because this was already covered by your previous topics. Therefore, what we will focus today is the remedies for your government and taxpayer as your administrative remedies, judicial remedies for government, and the same is true with your taxpayer, which is your administrative remedy and judicial remedy for your taxpayers. Since we had already an idea on what we should learn on this particular topic, we could now start and talk about your government tax remedies, starting from your administrative remedies. So the first administrative remedy of the government is your assessment. So what is an assessment? Assessment is similar to audit. It is a finding by the taxing authority that the taxpayer has not paid the correct taxes. As I told you when we talk about your assessment, it is the same with the term audit. So, what happens with your assessment? Generally, we try to audit a particular taxpayer. We audit a particular taxpayer. So, the question is, who is this taxpayer to be audited? If you still remember, we said before in our previous discussions that when we talk about auditing a taxpayer or assessing a taxpayer, we don't assess those small fishes. We try to assess those big fishes. And when we talk about big fishes under your taxation, we call them your medium and high risk taxpayers. So they are your medium risk and your high risk taxpayers. Medium risk and your high risk taxpayers. So we try to audit them. So when we try to audit them, what type of audit do we make use? So if we try to audit or assess a particular taxpayer, we could go with the regular audit, which is your assessment process, or we could do a JPRD assessment. So what is the difference of this regular audit based on an assessment process, and what is the difference of this audit to your JPRD assessment? So first, your regular audit or assessment process go to the actual assessment process done by the BIR. So it's the normal assessment process done by the BIR. Later, we will lay down what is the process made by the BIR in assessing a particular taxpayer. How about a geopardy assessment? So when we talk about your geopardy assessment, this is type of an audit made by the BIR in case there is a belief made by the BIR that the taxpayer would jeopardize the audit process of the BIR in getting the real or correct taxes of a particular taxpayer. So when can we say that your taxpayer will jeopardize the audit process of the BIR? Take note, you will only use jeopardy assessment if there is a belief. Actually, the word used by the law is a belief. It is not a reasonable belief so long as there is a belief that the taxpayer will jeopardize the audit process. So the question is, when will the taxpayer will jeopardize the audit process of the BAR? So it is known as jeopardizing the audit process if in case the taxpayer will not comply with the audit process of the BIR. Therefore, you will use your Jeopardy assessment. You will use your Jeopardy assessment. So again, in your assessment, what we look into is we try to audit a particular taxpayer. And what are those or who are those taxpayers? Those are your medium and high risk taxpayers. And when we talk about audit, that can do your that can be your assessment process or your zero body assessment, depending on whether we can say that the taxpayer will comply or will not comply with the audit process. Now, with your audit, take note, with your audit, what happens is that we need to determine if ever the taxpayer did not pay the correct taxes, or the taxpayer fraudulently filed his or her taxes, or there are irregularity as to that particular taxpayer. So once this had been established, we could already provide for your preliminary assessment notice, or your PAN, preliminary assessment notice. Later, we will discuss what is this preliminary assessment notice. Okay, so what is this preliminary assessment or this assessment? So how will that assessment works on your taxpayer? So the assessment contains not only the computation of tax liabilities, but also demand for payment within a prescribed period. So take note, what happens here in your assessment is first we determine if ever the taxes were correctly paid, there's no fraud, and the filing is regular. But once any of this is present, therefore we should assess that particular taxpayer, and that is through your PAN. But actually, it is not only PAN, but we also have your FUN FLD. FUN FLD. Sir, what is that FUN FLD? This FUN FLD is your final assessment notice and final letter of demand. Sir, why do we call it FUN FLD? We call it FUN FLD because as a result of your assessment, we need to assess, or we already determined that there is a tax liability on a particular taxpayer. So the computation of your tax liability is provided in your assessment notice, of course, and the demand for payment is in your final letter of demand. Okay, in your final assessment notice, take note what is assessed, of course, is the total tax liability. Again, what is the components, or what are the components of this total liability? The following are the components of the total liability. First, again, is your basic tax due. Next, we have your interest. We also have your surcharge, and we have your compromise penalty. So those are the items of your tax liability. Again, we audit first the taxpayer, and after the result of our audit, if we determine that there is an incorrect tax, or there is a fraudulent tax, or irregular tax filing or tax return, then what do? We provide an assessment notice. And how do we provide for an assessment notice? The assessment will contain the computation of your tax liabilities, including the demand for payment within a prescribed period. Now, the question is, when do we assess a particular taxpayer? So, a taxpayer is assessed within 3 years after the due date for the filing of a return, or from the day the return was filed. What do we mean by this again? It is your filing or deadline, whichever is later. Do you still remember that? We have discussed that during your midterms. So we can assess a particular taxpayer within 3 years from the date of filing or deadline, whichever is later. And if ever the return is amended, from the date of amended return. So the date of amended return. But if the return is false, fraudulent, or there is non-filing of return, when can we assess it? Within 10 years. Within 10 years. So for example, we have uh, an annual ITR. So this is due April 15, let's say 2021. So annual ITR 2020, annual ITR due April 15, 2021. And it was filed on, let's say, August 1, 2021. Assuming it is not false or fraudulent, When is the last day to assess it? Within 3 years, right? From the date of filing or the date of deadline. So date of filing 8/1/21. Date of deadline is April 15, 2021. When what date is later? The date is August 1, 2021. So within 3 years. So when is the last day? So plus 3 years. So this is until 8/1/2024. Okay? Within 3 years from the date of filing or deadline, whichever is later. Now, assuming that it is false or fraudulent. Assuming it is false or fraudulent, we have until 10 years. So that is 8/1/2021 until 8/1/2031. 8/1/2031. Okay? So, why is it important for us to determine the assessment period? Because if the assessment is made after 3 or 10 year period, it is considered void. If the assessment is made after 3 or 10 year period, it is considered void. Therefore, you must really assess it within the period. Okay? So the government must assess you within that period. Sir, what if I receive an assessment after the 3 or 10 year period? What is the effect on my business? The effect on your business is that it will not really affect your business. Why? Because that assessment is void. It does not it will not give authority on the BAR to audit you or to assess you because again it is already prescribed. Actually, this 3 years or 10 years is known as your prescriptive period. So after this period, the right of the government already prescribed. The right of the government already prescribed. Okay? So it is from your 3 or 10 year period. If not, it is considered void. So after knowing your assessment, let's look into the process of assessment or the regular assessment. So as a government remedy or as one of the administrative government remedy, we have here your assessment. So we follow this regular assessment process. Okay. So what is the regular assessment process? Before we go with your LOA, we first have, of course, the determination by your BIR of the medium or high-risk taxpayers. And if there is a belief that the medium or high-risk taxpayer filed an incorrect return or a fraudulent return or an irregular return, the government, the BIR now, will issue a letter of authority. A letter of authority. Again, from your medium or high risk taxpayers, we determine if ever their tax is incorrect, fraudulent, or irregular. And then the BIR will now issue a letter of authority. So, what is this letter of authority? So, this letter of authority, LOA or letter of authority. This is an authority given to a particular revenue officer to investigate or audit the taxpayer. Okay? This letter of authority is an authority given to a revenue officer to investigate or audit the taxpayer. Now, this letter of authority, once issued to a revenue officer, it must be given or furnished to the taxpayer within 30 days. It must be furnished by the taxpayer within 30 days. So you must inform the taxpayer using your LOA that the taxpayer will be audited. By the way, the LOA should state what particular taxable period and what tax returns are to be audited. So for example, the BIR would want to audit your VAT returns taxable period 2018, that can be. So it must be specifically provided under the LOA on what particular returns or return will be audited and what taxable period will be audited. Now, after it is furnished to the taxpayer within 30 days, of course, the revenue officer can now do its audit or investigation. Audit or investigation. So this is again pursuant only to the letter of authority. So once there is already a letter of authority, after it is furnished, again, the revenue officer can now do its audit or investigation. The question is, what is the period of the audit or investigation of the revenue officer? The investigation by the revenue officer can last up to 120 days. 120 days. So what is the result of this investigation? The result of this investigation is either there is incorrect, fraudulent, or irregular return, or there is no, or there is a correct return. If there is a correct return, then what happens now with the investigation is that it is now terminated. It is now terminated. But what if the revenue officer, after 120 days of audit or investigation, determined that the taxpayer has an incorrect, false, or fraudulent, or irregular return? What happens? You will now go to an informal conference. So, NIC, notice of informal conference. So in that notice of informal conference, of course, you will confer now with the taxpayer regarding the results of your audit or investigation. So in the results of your audit and or investigation, you will now confer it with the taxpayer, and at the same time, you will issue now your PN or PAN. What is this PN or PAN again? PN or PAN is your preliminary assessment notice. So what is provided here in your preliminary assessment notice? So again, your total tax liability as a result of the audit or investigation. Okay. Now, of course, what will happen to the PAN? The PAN will be received by the taxpayer. The PAN will be received by the taxpayer. So within 15 days, the taxpayer must reply. Within 15 days, the taxpayer must reply. Okay. I place yellow here for the action of the government, and we place blue for the action of the taxpayer. Okay. So what will happen? Once the BIR now will issue the PAN to the taxpayer has 15 days from the date of receipt of that PAN to reply on the PAN. So again, what is this reply? We said that the reply is considered a remedy of the taxpayer. So what can be included there in the reply? That perhaps there is a mistake on the computation, that the following items are already barred by prescription. What do we mean by barred by prescription? You all know that, as you said before, you must only assess a particular taxpayer for 3 years or 10 years, 10-year period, depending on the ground. Now, if ever you think that the assessment was already made beyond the period of prescription, then you could also place that in your reply. So that is one of your remedy. You can reply it already that you cannot assess me on this because your right has already prescribed pursuant to the law that you can only assess me within 3-year period. So again, once receipt of PAN, you can reply, the taxpayer can reply within 15 days. Now, after your reply, what happens in your reply is that if ever the assessment will still continue, so if the reply is meritorious, what happens can uh, what happened will be that your assessment or the assessment of the BIR can be terminated. So if the reply is with merit, so let's say it is really beyond the prescriptive period, then the assessment will be terminated. If not, it will continue. So what will happen? The government now will issue your FLD fund. What is your FLD or fund again? Your FLD or fund is known as your final assessment notice, including your final letter of demand. So as we said a while back, what is included in your assessment is the liability and the demand for payment. This is already your FLD or fund. Okay? So upon your reply, if the BAR find that your reply is without merit, that you are really liable out of that particular tax investigation, then they will now issue your FLD or fund. So the FLT or fund issued by the government or the BAR, upon receipt by the taxpayer can reply within 30 days. Within 30 days. So what do we call the reply of the taxpayer for an FLD or fund? We call it a protest. So you try to protest now your FLD or fund. In your protest of FLD or fund, you have two modes. You have two modes of protest. That is either investigation or reinvestigation or reconsideration. Okay? So the protest has two grounds. What are the two grounds for protest? That is either reconsideration or reinvestigation. So when can we use reconsideration and when can we use reinvestigation? We can use reconsideration if ever you try to protest the assessment based on old evidence or old data. Meaning, for example, this is the data used for the audit. Now, you protest it based on that data alone. How about if reinvestigation, there is a newly discovered evidence or new data? There is a newly discovered evidence or new data. So this is the old data. There is a new data which now could remove the liability of the taxpayer or exonerate the liability of the taxpayer. Okay, so what is the period of reconsideration? The period of the reconsideration is 180 days. So within 180 days, what will happen? The CIR or its authorized representative must decide based on that reconsideration. Okay, so what if the decision of the authorized representative, you are liable? If you are liable, then you must pay. If you are not liable, then no problem. If you are liable, again, as we said, this is the whole administrative remedy. You can now go to a judicial remedy. If you are still liable, then you can protest it or you can appeal it using a judicial remedy. What if reinvestigation? Take note in reinvestigation, what differentiates reconsideration to your reinvestigation is that in your reinvestigation, there is a newly discovered evidence. Since there is a newly discovered evidence, then you are given 60 days to submit documents. You are given 60 days to submit documents. What is the submission of documents? What documents will you submit? That is your newly discovered evidence. Take note. What's the difference? In your reconsideration, after filing of reconsideration, the CAR or its authorized representative has now 180 days to decide. But if ever you use reinvestigation for your protest, you are given first 60 days from the date of reinvestigation or the protest of reinvestigation or the ground of reinvestigation to submit documents. What documents are this? These are your newly discovered evidence. After that, again, you have 180 days or the CIR has 180 days to decide regarding the protest. Okay. So again, we look into the whole government remedy as to your assessment. So it all starts from the determination of the medium or high risk taxpayers in case that the system of the BAR tagged them as having an incorrect tax return fraudulent return, or irregular return. So what will happen is that there will be a letter of authority issued to a revenue officer, and it must be furnished to the taxpayer within 30 days. And after furnishing it to the taxpayer, or after giving notice to the taxpayer, then the revenue officer can now do its audit or investigation within 120 days. As a result of that audit or investigation, it is either determined now by the revenue officer that the taxpayer filed correctly or incorrectly. If filed correctly, therefore the assessment is now terminated. But if incorrectly, what will happen is that they will have a notice of informal conference. They will talk about the results of the investigation. Now, after that, the BIR will now issue the preliminary assessment notice, which provides now the total tax liability as a result of the audit or investigation. After the receipt of the preliminary assessment notice, the taxpayer has 15 days to reply. That is to dispute the preliminary assessment notice. After your reply, if ever it's still found that the taxpayer really is liable, then the government can issue an FLD fund. What is this fund, or FLD or FLD fund? This will provide now for the total tax liability or final tax liability of the taxpayer together with the demand of payment of that liability. But if the taxpayer really thinks that the FLD or fund is incorrect, then the taxpayer could protest. And what are the grounds for protest? It is either reconsideration or reinvestigation. Reconsideration based on the existing or old data or evidence, while for reinvestigation, we have based on the existing together with the newly discovered evidence or new data. So if ever your ground for protest is reconsideration, the CIR should decide within 180 days. But if the ground is reinvestigation, the taxpayer is given 60 days to submit documents as to that newly discovered evidence, and the taxpayer, upon submission of the documents, will wait for 180 days or within 180 days for the CIR to decide. For the CIR to decide. And after this decision, if ever it is again not in favor of the taxpayer, if the decision is not in favor of the taxpayer, what is your next step? You can go now to your judicial remedy. You can go now to your judicial remedy. So we finished already talking about one government administrative remedy, and that is your assessment. We proceed now to other government administrative remedy, that is your collection. So, as we said earlier during our introduction, that your government administrative remedy collection can either be an actual collection by the payment of taxes of the taxpayer, which is duly assessed, but it can also be a summary proceeding or summary remedy done by the government. So, what is collection? This is the enforcement of the payment of tax. So, remember, after your assessment or final assessment, then you can now enforce payment through collection. So how do you enforce payment? That is either actual collection or actual payment by the taxpayer, or it is through your summary proceeding, which are your disdain, levy, forfeiture, and your lien. So how do we enforce your payment? That is either actual payment by the taxpayer, or we can have this summary proceedings. The question is, when do we collect, or when do we enforce payment by the taxpayer? So it depends whether there is a previous assessment or there is no assessment. If there is a previous assessment within 5 years from the date of final assessment. If no assessment, that is within 3 years. If it is not false or fraudulent, or it is not, if it is properly filed. Properly filed. Not false, fraudulent. or it is properly filed. And 10 years if it is false or fraudulent. Okay, so when do we collect? If ever there is an assessment, it is within 5 years from the date of the final assessment. If there is no assessment, it is your 3 year and 10 year period. Why? Because again, we said that this 3 year or 10 year period is the prescriptive period. So there must be an action within that period, 3 years and 10 years, because if not, then the government could not collect from the taxpayer. Okay. So again, once there is an assessment, you could enforce payment. But what if there is no assessment? You go back to the original rule of the prescriptive period, which is the 3 years or 10 years. So collection without prior assessment, if not false or fraudulent, within 3 years. If the return is false or fraudulent, within 10 years. If it is without prior assessment. But if it's with prior assessment, it will always be 5 years from the date of the final assessment. Now let's talk about your different summary proceedings on collection. So the first is distraint. So what is this government remedy of collection, which is distraint? When we talk about distraint, this is the seizure or taking by the government of personal property, tangible or intangible, to enforce payment of taxes. To enforce payment of taxes. Okay, so generally, you can only collect if ever there is now a there is no reply made by the taxpayer. Therefore, the PAN is final. And assuming there is a reply and there was FAN, there is no protest made by the taxpayer. So again, the FAN is final. And assuming there is FAN and there is protest, so the denial of protest of the taxpayer, then again, fund is final. What if after protest they elevate it to the court? If denial of appeal by court, then you can collect. So these are the different instances wherein the government can collect taxes. If there's no reply made by the taxpayer, remember you must reply. If there's no reply, then the PAN is final. If ever there is PAN and then there is a reply, so there was no an issuance of fund, but you did not protest. If there's no protest made, therefore the fund is final. What if you protest? What if you protest and there is a denial of protest? Again, the fund is final. What if there is a protest and uh, it was already decided against the taxpayer, and the taxpayer now appealed to the court. And if that appeal was denied again by the court, then you can already collect. Now, one mode of collection is distraint, which is the collection which you try to seize or take the personal property of a particular taxpayer. So when we talk about distraint, again, it is personal property. And distraint can either be actual or constructive. When we say actual, it is made only on the property of a delinquent taxpayer and there is taking of possession. When there is constructive, it is made on property of any taxpayer, whether delinquent or not. So take note, only on a delinquent taxpayer if actual distraint, and if it is constructive distraint, whether delinquent or not delinquent taxpayer. Finally, in a constructive distraint, the taxpayer is merely prohibited from disposing his property. So only a prohibition. Here, the property is already taken by the government. So in actual distraint, the property is taken because the possession now is taken by the government. But in constructive distraint, what happens only is a prohibition that the taxpayer could not dispose that property. So what is the whole process of this distraint? The whole process of this restraint, of course, it starts with the preliminary collection letter. Preliminary collection letter. So in this preliminary collection letter, of course, it states now the demand for collection regarding the final assessment. After that preliminary collection letter, you will provide, or the government will provide, for a final notice. Final notice as to your collection. Now, if ever on your final notice, of course, your taxpayer can either pay, or there is an actual payment by the taxpayer, or the taxpayer will not pay, therefore the government should employ summary proceedings. So assuming the summary proceeding provided is restraint, assuming the summary proceeding provided is restraint, what will happen? What will happen is that there will be a warrant of distraint to be issued now to your taxpayer. Under that warrant of distraint, the property will be identified. The property to be distrained will be identified. And upon identification of that distrained property, we now provide a notice of distraint on that property identified. So a warrant of distraint, and we identify the property to be distrained, and then we provide a notice of distraint. Notice of distraint. And after your notice of distraint, the property now will be auctioned. Auctioned, and whatever is the proceeds, it will be applied to the tax liability. Right? It will be applied to the tax liabilities. Third question, what if the process is not enough? Actually, this different modes is not exclusive. These modes are not exclusive. When we say they are not exclusive, it means you can restrain and at the same time levy a property because it is not exclusive. Take note of the process. It all starts whenever there is already final notice and the taxpayer cannot really pay. Then you could use your summary proceedings, and in our summary proceeding here, we use your distraint. So in your distraint, we provide for a warrant of distraint, and then we identify the property, we provide for a notice of distraint, and finally, we try to auction that property, and any proceeds out of the auction of the property will be used to cover the tax liability. Right? That is distraint. Take note, personal property. How about levy? How about levy? As a government remedy for collection, this is one of your summary proceedings again. If ever levy, we try to seize or take a real property. So here, it is a real property. So what is the difference between a distraint and levy? In your distraint, we have a personal property, while in your levy, we have a real property. In your distraint, forfeiture is not provided. In your levy, forfeiture is authorized. And then, in your distraint, there is no right of redemption, while in your levy, there is right of redemption. Sir, what is this right of redemption and what is this forfeiture? We start first with your right of redemption. Under the law, if ever that is a real property, any real property that is mortgaged, and then finally it is foreclosed or it is auctioned, the owner of the property could redeem that real property. Normally, that right of redemption is 1 year. So any real property. So for example, you mortgage your real property to the bank and the bank foreclose your real property. So you have 1 year from the date of sale of that real property to redeem that property within 1 year. So therefore, it still applies here because it is a real property. Therefore, there is a right of redemption. And generally, redemption only applies to real property, not to personal property. That's why there is no right of redemption on a personal property, but there is right of redemption on a real property. Let's talk about your forfeiture. Remember the process. So once there is already a final notice and there is a non-payment, di ba? There is a final notice and we can say there is non-payment, therefore we employ a summary procedure. And let's say your summary procedure here is a levy. So how does your levy works? Of course, your levy works by starting with your warrant of levy. You will issue a warrant of levy to your taxpayer, and you will now identify the real property. After identification of the real property, the next step again is to have a notice on that particular property that it is already levied. Notice of levy on that real property. And after the notice of levy, it will be auctioned. Okay, so they are almost the same with your distraint. That in this case, the warrant is only warrant of levy. In distraint, it is known as warrant of distraint. The notice here is known as notice of levy. In distraint, it is known as notice of distraint. But the difference lies on this auction. Why? In your distraint, in your distraint, if no bidder, it cannot be forfeited in favor of the government. If no bidder, it cannot be forfeited. So it is not provided to the government. But in levy, if no highest bidder, it can be forfeited by the government. Take note of that. In a levy, a real property can be forfeited, and at the same time, there is a right of redemption. While a personal property, it cannot be forfeited, and there is no right of redemption. So actually, their main difference lies as to the type of property. Personal property for distraint, real property for levy. And aside from that, the forfeiture and the redemption. Forfeiture can be done in levy, but no forfeiture in distraint. There is no right of redemption in distraint, and there is right of redemption on your levy. So again, their difference lies on this last part, auction. If there's no bidder in distraint, it cannot be forfeited. If there's no highest bidder in levy, it can be forfeited in favor of the government. In favor of the government. Do not forget that. And at some point, this distraint levy is also compared to your garnishment. Garnishment. So what is the difference of this distraint levy and garnishment? So first, as to ownership, distraint, levy, and garnishment. So as to the owner, in a distraint, the owner is a taxpayer. Levy, the owner is the taxpayer. Garnishment, the owner is the taxpayer. The next question is, who is in possession of the property? In distraint and levy, the possession is held by the taxpayer, but in garnishment, it is held by a third person. What is the example of a garnishment or a property under garnishment? You have your bank deposits. So in a bank deposit, the owner is the taxpayer, of course. But who possesses the cash? Who possesses it? It is the bank. The bank is considered here the third party. Okay? So again, it is just a matter of term used in taking the property. So if you are taking a personal property, if you are taking a personal property, it is either distraint or garnishment, depending on whether it is possessed by the taxpayer or not. Okay, so as to the type of property, in distraint, it is personal. Levy, it is real. In garnishment, it is personal. As to the right of forfeiture, in distraint, it cannot be forfeited. In levy, it can be forfeited. In garnishment, it cannot be forfeited. Okay? Why? Take note here. You can forfeit here to meet the division C in levy, but in garnishment, it must be purchased by the government. That is different. Because in forfeited, what happens is that there is no more, there is no need to pay the taxpayer. Here, you must purchase it. Okay? So do not forget these differences. In distraint, ownership and possession, taxpayer. Levy, ownership, possession, taxpayer. In garnishment, ownership, taxpayer, possession, third person. As to the type of property, distraint, And garnishment, personal property. In levy, real property. As to the right of government to forfeit the property in case of non-bidding, in levy, you could do so. But in distraint and garnishment, you cannot. You cannot. Okay? Levy, distraint, and garnishment. Another government remedy is a tax lien. So what is a tax lien? A tax lien is a legal claim or charge on property, either personal or real, established by law as security in default. The extent of the lien shall be with the interest, penalties, and costs that may accrue with the registration of the tax lien. So what's the difference of this lien? In a lien, it is like your it is only a notice. It is only a notice of right to collect on a taxpayer. So you have a right over that property. You have a lien over that property. While in a levy or distraint, what happens here is that you don't give a notice, you will take the property. In a lien, only a notice or purely legal claim or charge. But in a levy or distraint, there is a taking. Remember that. There is taking in levy or distraint. In a lien, you will only give a notice or a claim or a charge on a property, whether the property is considered real or personal. Another government remedy as to your collection, if ever you employ your summary proceedings, is your forfeiture. Remember, when can we have forfeiture? You can only have forfeiture under your levy. You can only have forfeiture under levy. And when can you forfeit? If there is no bidder. There is no bidder. Okay? And what is the effect of your forfeiture? That is to transfer the title of the specific thing from the owner to the government. Because again, it is now forfeited in favor of the government. Please take note, when can we have forfeiture? So when can we have forfeiture? Only after your auction and it was determined that there is no highest bidder, particularly in case of levy. Because only real property can be forfeited. Sir, question, after forfeiture, what can be the remedy of a taxpayer? Remember, once it is forfeited, the remedy of the taxpayer is to redeem the property. Okay? The remedy of the taxpayer is to redeem the property. Sir, how will the taxpayer redeem the property? Of course, you will pay the cost of the forfeiture. You will pay the cost of the forfeiture. Okay? So we have discussed the different procedures in the collection or the different summary procedures in the collection of the government. And what are those summary procedures again? So the summary procedures that we have talked or we have discussed are first levy, next is restraint. We also talk about your garnishment, and we also talk about tax lien and your forfeiture. Tax lien and your forfeiture. We go now to your judicial remedies for the government. So what are the judicial remedies on your government? So the first judicial remedy is a civil action. So what is the civil action here? This is to enforce the collection of your tax. So once it is considered demandable, you can file a civil action for the collection of a sum of money against the erring taxpayer. So civil action is resorted to if ever we are now to collect on the taxpayer. And also, we can have a criminal action. When we say criminal action, normally the main criminal action that we can file against the taxpayer is known as your tax evasion. The main criminal action that we can file against the taxpayer is your tax evasion. So these are the different judicial remedies. Normally, these judicial remedies are made now by the government lawyers. It is not made by just the BAR itself, but the government lawyers. So civil action for the collection or enforcement of collection, and criminal action that can be constituted against the taxpayer to be penalized, normally tax evasion. Now, after we talk about your different administrative and judicial remedies under your government, we are now ready to talk about your administrative and judicial remedies on the part of the taxpayer. We start first with the administrative remedy of the taxpayer. Okay, so what are the administrative remedies of the taxpayer? So the first administrative remedy of your taxpayer is protest and reply. Remember that we have discussed it a while back. So when can we use your reply? We can use your reply to dispute the preliminary assessment notice. So you use reply to dispute the preliminary assessment notice. Remember that. What you dispute in a reply is the PAN. So it is the PAN that you try to dispute in your in your reply. How about in protest? What do we try to dispute? What we dispute under your protest is your final assessment notice. Final assessment notice, FLD, FLD fund. Final letter of demand, including your final assessment notice. So what are the grounds again in your protest? Reconsideration and reinvestigation. When do we use reconsideration? If ever it is based on your old data or old evidences. Reinvestigation if there is a new data or new evidences. Actually, you use only protest and reply. So you only use protest and reply. So you use protest or reply. So you only use protest or reply, guys, if in case uh, that is based on an assessment. So normally underpayment of taxes. So if ever we did not pay the correct taxes, your remedy is a protest or reply. But what if we overpaid taxes? Again, if we underpaid taxes, we use protest or reply. But if we overpaid taxes, what is our remedy? Your remedy now is either refund or credit. So when can we use refund or credit? If ever the tax is collected erroneously or illegally kasi nga sumobra yung tax, the penalty is collected without authority or the sum collected is excessive. Or in short, we have overpayment of taxes. Again, what is your remedy if you underpaid taxes? The remedy to if you underpay taxes is a protest or reply. That is your administrative remedy. What is your admin remedy if you overpaid taxes? That is either refund or tax credit. Okay? And take note, when is the period of refund or tax credit? You all know this one. We have discussed this one in your tax 1 and tax 2. You must file for a refund or credit within 2 years from the date of overpayment. Okay? Underpayment, protest or reply, overpayment, refund, or credit. So those are the administrative remedies of a taxpayer. How about a judicial remedy? The main judicial remedy of your taxpayer is to appeal. So you appeal through the petition for review to the CTA. CTA is the Court of Tax Appeals. So remember a while back our flow chart. If in case, guys, what happens is that there is a denial of your protest. So after reconsideration or reinvestigation, your protest is denied. Your next step is to appeal it to the CTA through a petition for review. Sir, what if our petition for review to the CTA is also denied? Then you can now elevate it to the Supreme Court. So you appeal to the Supreme Court or you can have a certiorari to the Supreme Court. Okay? That's one of your judicial remedy. Sir, question. What if they will now enforce the summary procedure in my favor? So what is the summary procedure that can be enforced against you? The summary procedure that can be enforced against you is, of course, the collection through levy or distraint or garnishment, including the auction of that particular properties. So what can we do there, sir? The thing that you can do with that is injunction only. But as a general rule, guys, as a general rule, there is no action that can suspend the collection, payment, levy, distraint, garnishment, sale, or auction of the property of the taxpayer. Okay? As a rule, okay? As a rule, as I told you, there can be no action that could suspend the collection, the payment, the levy, the distraint, the garnishment, or the sale or the auction of your property. So once the government employ those summary procedures, you cannot suspend them. You cannot suspend them. That is just a general rule. What is the exception to that rule? The exception to that rule is you can file an injunction, but it is only when the CTA is, in its opinion, says that the CIR jeopardize the taxpayer. So it could jeopardize the taxpayer. So for example, the taxpayer can only has only a real property, which is your house and lot, and that is also the place of the business of the taxpayer. Now, what will the CIR do is to take the real property. So if the real property is taken, of course, what will happen to the taxpayer is that there's nothing left on the taxpayer to start again. So if the CTA is in opinion that it could jeopardize the taxpayer, the CTA can give an injunction. What is the effect of that injunction? It could suspend now. Because as a rule, as we said, as a rule, you cannot suspend. But if the CTA, in its opinion, could jeopardize the taxpayer because of those summary proceedings, then the CTA could provide an injunction. Sir, what is the rule why the court cannot suspend the collection of taxes? Because, as a rule, taxes is the lifeblood of the government. Therefore, you could not step on the boundaries of the government to continue its existence through its taxes. That's why they could not really suspend it. Because again, judiciary is part of the government. So if they try to suspend the collection of taxes, the government will be paralyzed. The government will be paralyzed. Take note of that. So what are the judicial remedies of the taxpayer? In case, guys, all of the administrative remedies of the taxpayer. So for example, their protest is denied. They could appeal to the CTA. Their petition for refund or credit is denied, they can again appeal to the CTA. Those are the judicial remedies. If after the CTA, what happens is it is still denied, they can now appeal to the Supreme Court. Okay? Why? That the taxpayer remedies are easier to understand than the government remedies. But once you can look into it in a way that there is the action of the government and this is the action of the taxpayer, this type of lesson or this topic, it would be easier to understand. So if you know that if this is the action of the government, let's say the government gives a fund, what is the possible remedy of the taxpayer? Provide a reply. If the government will provide for a fund, what is the action of the taxpayer? Go win a protest. And if the government will now deny the protest, what is the action of the taxpayer? That is to appeal to the CTA. If the government now if the CTA will favor the government, what is the action of the taxpayer? That is to appeal to the Supreme Court. What if the government will deny the refund or credit? You can again appeal to the CTA and finally appeal to the Supreme Court. So that's it for our remedies. Again, your remedies apply to both your taxpayer and your government.